Okay, good morning, everyone. So today I'll be taking up block 3, unit 3, regarding critical analysis of environmental laws and acts for effective environment management. So in the last two units, in unit 1 and unit 2, we have seen what is policy, how policy making is important, who takes up policy making, who are the decision makers and policy makers, and what are the national environmental policies in India which are important for environmental governance and sustainable environment management in India. And today I'll be taking up the third unit, which needs to study the environmental laws and acts which have been formulated under the environmental policies, which we have already gone through in unit 2. So it is basically a continuation of unit 2 itself. And after this unit, in unit 4, we'll be studying further regarding the tools and strategies which are available under these environment laws and acts for effective environment management, like environment impact assessment, social impact assessment. I'm informing you regarding the subsequent unit because in last lecture also some students had the questions, please give us more information about EIA and EMP. So you should be assured that in the next unit, we'll be taking up all those tools and strategies in detail. So today we'll be taking up just environment laws and acts and rules and guidelines under those acts and the penalties involved, so that you can focus on this particular unit itself. So outline of the presentation, as I have already informed, will be regarding the constitutional measures for protection and preservation of environment, legislative measures, the Indian Forest Act 1927, the Water Prevention and Control of Pollution Act, the Air Prevention and Control of Pollution Act, the CES Act for Water 1977, then amended 91, and Environment Protection Act and Environment Protection Rules in 1986. Then Hazardous Waste Management Act, Municipal Solid Waste Act, Ozone Depleting Substances, Plastic Waste Manufacturing Act. So all these acts, these are basically the years and the name which were originally formulated. So they have been subsequently over the period of last decade and last 10 or 20 decade, 2 decades, they have been amended off and on, and they have been before any amendment takes place, they are put into the public domain, and they are asked for public comments and public feedback, so that all the experts of environment in the community or as per the stakeholders community, they can give their feedback, and therefore there can be amendments which are implementable. Okay, so that's why these whenever these guidelines and acts, before they are finally finalized by the constitution or as a gazette notification, whenever they are put into the public domain, it is our responsibility as stakeholder give our feedback, to go through them, and through our personal email only we can give feedback to the ministry regarding any acts or rules in environment domain. So basically India, at last session also I told you there are more than 200 laws and acts which directly or indirectly involve environment management and sustainable development. So basically, we cannot cover 200 laws and acts, and each law and act varies from 5 to 30 to 50 pages. So related act and LARR related act, Land Acquisition, Rehabilitation, Resettlement Act. So all those some acts are so lengthy and so voluminous that we cannot cover each and every clause of every act. So basically, we'll be discussing the key features of every act so that you have you have an overall perspective regarding what are the clauses and what are the penal actions which are available under our environmental acts. So basically, it started like India was an original signatory. Last time also we discussed why policy making came into picture in India and why India is recognizing importance of environment acts and rules under its various constitutional provisions. So basically, India is an original signatory to the Solemn Declaration of the United Nations Conference held in Stockholm, and it from there on, from fourth five-year plan of our formulated in 1968 to 73, we have started integrating environmental dimensions into our planning and development processes. So basically, India was first country which incorporated environmental related guidelines under its constitution. Okay, so till then, from then till now, the government of India has adopted various measures for conservation and upgradation, and we'll be going through all those adopted measures in subsequent slides. So the laws enacted have been at different levels of administration, at central level, at state government, at local level, at judiciary level, and all these are affecting the industrial as well as domestic activities in our country. Okay, so objectives of this unit are basically to understand what is the legislative framework which is applicable in India, and for any kind of industrial activity or even for the domestic activities, we have some responsibilities as well as some provisions as well as some pleasures. Okay, so those pleasures can be accrued to us only if we are going to protect our environment and fulfill our responsibilities. The pleasures of having a healthy life, having clean air, clean water, and all basic like the criteria which governs the Human Development Index. All these criteria are basically related with availability of uh, environmental resources which are required for the sustenance. Okay, so then to discuss the reason for and objectives of each environment law, why this environment law was enacted, and what are the landmark judgments regarding environmental issues of India. Those landmark judgments are like classical judgments or historical judgments in the field of environment management, and to study and identify critical gaps or lacuna in these acts so that we can in future, if there are any amendments, or in future if we have to take up any projects, we can take care of these gaps. Accordingly, we can prepare a better environment management, and we can adopt better tools and strategies for environmental governance. So basically, the need is because of the rapid growth in an economic activity over the years. So you can see how the population, urban population, total real GDP, foreign FDI, and damming of rivers, as well as paper consumption, water use, all these criteria or the indicators inform you that there has been a rapid economic growth and activity over the last 3 decades. Okay. So due to this, there has been loss of biodiversity, deforestation has been there, rapid population growth, climate change, pollution, soil erosion, all these things, all these features of environmental degradation you have been already studying under this course in different units. So we are well aware why there is a need of environmental laws and acts. Okay, so being the first country in the world which has provided for constitutional safeguards for the protection and preservation of the environment, our constitution has given specific provisions under 42nd Amendment Act in 1976, under the Article 51AG, the article says it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. So basically, it is not just the requirement of the state to endeavor for improvement of environment. It is also, as per constitution, it is the basic responsibility of every citizen to protect and improve the natural environment. So if we, in spite of these constitutional arrangements, still we have to motivate and bring awareness to people to protect environment. And it's really tragic and pity to have this kind of situation in current scenario. But still, because people are not getting aware of what kind of challenges environment is being posed to due to degradation they are making through unsegregated waste disposal on roads or in community, or through air pollution caused due to excessive use of vehicles or excessive consumerism. These issues are causing environmental degradation on daily basis. But we have to realize that primary duty, it is our constitutional responsibility. Okay. So, as per legislative measures, there are different constitutional provisions which are implemented to environmental protection laws. Then there are recurrent amendments which are made by Ministry of Environment and Forest in the Government of India. So in last lecture we had a question by one of our students that why do these politicians, MLAs, these are not given any information or training regarding environment, because they are not they are implementing local level schemes and policies, but they are not the policy makers or the decision makers. So that is all these environmental laws and implemented by the Ministry of Environment and Forest and Government of India. And sometimes when we go for environment clearance, it happens many times that I am going for an environment clearance today, and there has been amendment yesterday, and which I'm not aware, because some on daily basis you are sometimes not able to update from the latest or amendment which got posted through Ministry of Environment Forest, but it should be done. Because sometimes you go for the presentation and the state level impact assessment authority or committee members, they so yesterday this kind of amendment happened, are you aware? So accordingly you should make changes in your project planning and your environment impact assessment report. So all these approvals, amendments, and recurrent changes which are there in our and rules, they are available on the website of Ministry of Environment and Forest, and there is a specific section where this notification and rules and guidelines are given. So once you will go through this website thoroughly, you will be able to identify कि कहाँ पे क्या होता है, what are the different changes, what are the different updations, and accordingly you will keep yourself updated. Okay, so the central parliament approves the laws and the implementing organizations are at the center and state level. These are at center level you have Central Pollution Control Board, at state level you have State Pollution Control Board and state level impact assessment authorities. So generally applicable environmental regulatory and implementation is structure is throughout India. It is same for all over the country, and certain state level updations and improvements can be made at state level itself. So accordingly,
अच्छा, एडमिनिस्ट्रेटर रिकॉर्डिंग को पोस्ट करके रखो. You can pause the recording.
Is it okay now?
अरे
Again,
हाँ
again there is a connection problem.
हाँ, कनेक्शन का थोड़ा इशू
Or
दिख
is
रहा
it
है.
okay?
फुल स्क्रीन नहीं आ रहा है. फुल स्क्रीन करो. हाँ, कनेक्शन फिर गैप हुआ. नहीं. थोड़ा स्लो हो रहा है ना. फुल स्क्रीन कर दीजिएगा. Resume slide show.
Now it's full screen.
Not exactly.
No.
आगे. Yes. आगे. You can continue.
Yes.
Okay. So sorry for this issue today in connectivity. So we were discussing what are the legislative measures through environmental laws in India and what are the different levels of central, state, local and industrial level where environmental laws and acts are applicable. So as per institutional arrangement for implementation of legislative measures at the state level, we have state pollution control boards. For urban areas, we have municipalities. So in all these acts and rules, there are specific responsibilities which are governed by state pollution control boards. Special powers are given to SPCBs and MCs of urban areas, and for rural areas, gram panchayats are responsible for undertaking administration related activities and as an implementing agency of these environmental acts and rules. So to implement the central laws concerning all environmental parameters, namely air, water and solid waste, road transport authorities are responsible for making plans and policies. At the judicial level, there are corresponding three levels: the Supreme Court, the state high courts, and the judicial magistrates, and the National Green Tribunal at the lower level. So the court examines complaints filed under the environmental laws either by the regulators at the magistrate level or by the citizens and civil society groups directly with the higher courts. So under the original jurisdiction of public interest litigation, these public interest litigations are governed by the magistrate level or by the citizen and civil society groups directly under these higher courts. So the higher court direct any so sometimes you will see nowadays National Green Tribunal is very active for taking action and any pollution related activity being taken up by any state level body, even and for the government penalties on these government bodies. So recently I have seen in Punjab, PSI, Punjab Infrastructure Development Board, their STP was visited by NGT and they were given wide fines ranging in crores because of the inaction taken by the local body, the government body. So there is no leniency in terms of environment management or operating your activities or operating your STPs, ETPs, or any environment management equipment for as per the design, as the state level laws and acts and the standards governed therein. Okay, so basically this is the outline of how the environmental governance and implementation are covering various laws and acts in our country. So basically we have central ministry which is notifying national laws, policies and standards, and we have judicial interpreting. Then environment and Ministry of Environment Forest, which is now known as Ministry of Environment, Forest and Climate Change. Okay, so climate change has been added in the nomenclature Ministry of Environment Forest itself to inform all stakeholders regarding the significance of climate change that is happening these days. So accordingly, though MOEFCC gives power to CPCB, CPCB then implements laws, state level policy and standards. And then we have urban and rural development board, then shipping roads, transport and highway department, then Supreme Court of India is there. And under that, all these municipals and municipality as well as state transport, stakeholders are acting. Okay, and at the local level, we have zonal offices, regional offices, like for Punjab Pollution Control Board also. At various district level, you have regional offices. In Mohali, it will be different. In Patiala, it will be different. Similarly, in Delhi, East Delhi is having different, West Delhi is having different. So all these state pollution control board are further having regional offices, regional heads, and regional all these regional officers will visit your project site to issue any kind of show cause notice or to regulate or take or to monitor your activities regarding any kind of pollution you are causing to the environment. Okay, and they have this power to make take any penal action even at the regional level. Okay. So basically, all these zonal offices and regional offices, they identify the point sources of hazardous solid air and water pollution. So there is the structure is perfect to take care of any kind of environment pollution activity which is being caused in our society. Okay, so coming back to the first law which was formulated under the environmental regulations, the Indian Forest Act 1997. So it was formulated at the time of British India. Okay, so it is an aftermath of Sepoy Mutiny, which was caused in 1857, during which the forest and forest dwelling communities, they were provided the rebels for safe hiding places. So East India Company administration prohibited, withdrew all SS rights and privileges to fuel, fodder, and other local uses, so that they can completely regulate and visit and monitor these areas, so that no sepoys or no rebellious groups can take shelter in these forests. So basically, British India enacted this act of Indian Forest Act 1927, just to weaken the kind of revolt that was happening at those time against the East India Company. So in order to legitimize government control through scientific operations, there were many legal instruments passed after that from 1865 to 1927. But after independence, when the East India Company, whatever law access rights and privileges they had withdrawn for the local people and the forest dwelling communities, those rights were given back after independence. But giving back those rights and local communities further worsened the situation rather than improving, because local communities are dependent on forest resources. So the government, though it gave back those rights, but it caused further degradation to those SS rights to the local communities. So there was a phase of commercial exploitation of for 1970, and it lasted till the commencement of 1988 National Forest Policy. Okay, so with the view of checking further deforestation, the president promulgated on 25th October 1980 the Ordinance of 1980s and a Forest Conservation Act of 1980. So the Indian Forest Act was changed to Forest Conservation Act. In the nomenclature itself, conservation was a word was added to give the significance of this amendment regarding the provisions of conservation. Okay, so in those provisions, state government declared the forest or wetland as a reserve forest or protected forest. So there were provisions for the protection and the reservation of certain areas of forest and through restriction on forest use of forest produce. So the following actions were prohibited in the reserved forest, and they cannot make a fresh clearing. They cannot deforest any area without prior permission from the state level and central level bodies, cannot fire to a reserved forest or kindling any fire or leaving any burning. Then they cannot trespass or cattle grazing cannot be taken place in these forests, and they cannot damage to trees. And mining or quarrying of stones or burning lime or extraction of limestones, any kind of minor minerals cannot be extracted from these forests. So all these provisions were given to ensure that there is minimum level of conservation ensured in our forest areas. Then in protected forest, the cutting, sawing, and conversion and removal of trees and timber was not allowed. So there were provisions that you can go for timber harvesting and scientific timber production, but it cannot be done in the area of reserve. So for any industrial activity also, you cannot do any industrial activity within the vicinity of 5 kilometers of a forest area. Independence, then came the Water Prevention Control Act in 1974. So it drew a draft for the prevention of water pollution, and the report of the committee was circulated among the state, central, and local level government. So the draft bill was prepared in 1965. So you can say after 9 years, it was passed by both the houses of the parliament, Lok Sabha and Rajya Sabha, and on 23rd March 1974, it was formulated as the first sectoral act, you can say, like for the water sector only. After the Forest Act of 1988 amendment, it was the first act for water. Okay. So here there were special provisions given to Central Pollution Control Board at the center and State Pollution Control Boards at the respective state levels. So it was basically a comprehensive legislation for preventing all kind of pollution and maintaining wholesomeness of water in streams, in rivers, in every kind of water. It was a single at times. So the functions of the central board at national level were to advise central government of matters relating with prevention. So all kind of scientific study will be done by CPC, and it will just central level bodies, state level government to ensure that these are the scientific studies, this is the pollution your industry is causing. So accordingly, you make policy and you make a amendment in your bylaws or regulations so that water pollution is prohibited and water pollution is controlled. Okay, then they can carry out and sponsor research like Department of Science and Technology and Ministry of Environment and Forest also. They can sponsor research and investigation into these water problems. They set up the standards. So before that, there was no standard of COD, heavy metals, minerals, even radioactive elements now have been added in our water standards. Okay. So these state level bodies, they create awareness as well as they monitor the standard. So board include, now we have discussed the central level board. So at state level, we have to plan for prevention and control. We have to advise the state government, inject sewage and industrial effluent, set up standards, and provision of joint boards for 2 or more contiguous states. And any dispute between the state board, the central board has the authority. Okay. So the main from the main causes which the stakeholders were the issue they can restrain and prohibit any industry. So they all pollution control board have been given power of visiting any industry which is causing any pollution and to ask them to issue them warnings and ask them to curtail that pollution and mitigate that pollution immediately. Otherwise, penal action can be taken against them, ranging from fine to imprisonment of 5 years. So to make an application to the court for restraining likely disposal of polluting matter, they have the responsibility of it is a responsibility of the pollution control board. If pollution control board is asking any industry to curtail their pollution, it is the responsibility of the industry to provide all the data related with their polluting streams and the production and other activities. Then they have the water prevention and control of pollution, and they have there. And in cess act they devise cess on water consumed. So in those times what cess was very low as per the schedule 2nd of the act. The rates at which the water supply can be the water supply can be charged by the industries was very low. But now this cess is very high, and the industries which are primarily dependent on water sources as their raw material, for example, the bottling units or the cold drink industry or the drinking water bottling plants, all these industries are, because the raw material is 80%, 80 to 90% only. Apart from that, there is power required, there is a requirement of fuel, or there is requirement of certain chemicals for treatment, or certain chemicals and products for enhancing the flavor, as well as to add the fizziness in their products. But apart from that, they are largely dependent on water as a raw material. So the cess is increased in these industries now. So that's taking care of water, artificial recharging is being implemented, rainwater harvesting is implemented, and they have to utilize better standards. Okay. Then there was in 1981 Air Prevention and Control of Pollution Act. After the United Nations Conference of 1972, it was done, and it was due to the industrialization and rapid growth, the air quality degraded, and there was a report in Environmental Research Institute, which primarily provided all the data and all the statistics to the state level as well the central level bodies regarding the degrading air quality in cities like Calcutta, Bombay, Delhi. So the act was drafted and finally passed by both the houses on 29th March 1991. Okay. So again, this act provides setting up of central level and state level boards for control of air pollution. So within the other same CPCB and SPCB guidelines for monitoring and implementing acts and regulations. Similarly, air pollution was also under the prerogative of state level and central level pollution control boards. So similarly, union territories, CPCB is empowered to perform the functions of pollution control board, because in union territories there were no state pollution board, so central pollution control board was given the power, and there was given the state there is any specific area or any where air quality is low below the standards, then they are empowered to declare that area as air pollution control area. Okay, so in that area, no new industry can establish or operate any industry in any pollution control board area without obtaining the consent from the concerned state board. So for any control area, there is requirement of CTE and CTO. So in the area where there is high pollution and there is an air pollution control board area, then that industry will not be given that consent to operate and establish for establish that because of deteriorating air quality. The cumulative load on the air canopy in that area is very high. So any new industry, if it comes up, it will add to the cumulative load of pollutants which are already there in that area of high pollution. So that's why this clause was added. Power was given under Air Pollution Control of Pollution Act. So there is basically categorization of industrial area recently, which has ordered the environment regulatory authorities to enforce and take into account the comprehensive environment pollution development, and it was not there at those times. So the CEPI, SEPI was allocated weight to various pollutants. So all those pollutants will have been given some credits or some weightage has been given. Dependent on that weightage and the receptors, the number of people which are affected in that area, additional high risk elements were also added. So these were all the which government calculation of comprehensive environment pollution index. Okay, so there are again standards and guidelines if you Central Pollution Control Board website, or otherwise also if you search on Google regarding the allocation of comprehensive environment pollution index, you will get the guidelines in PDF format, and you can definitely go through them in detail. Okay, so original CEPI assessment was undertaken in 2009, but the data was updated in 2016 and final report was given in 2018. So then NGT was directly supervised the enforcement of CEPI, and accordingly they have ranked as critically polluted area, severely polluted area, or other polluted area. So in critically polluted area, no new industry can establish itself. So even if somebody wants to take environment clearance in a critically polluted area, it won't be given. And if it still has to apply then or try for the permission, it will go to the central level body or the central environment clearance body. Okay. Then the Environment Protection Act came in 1986. This was after the Bulgaria strategy, and it was basically called the Umbrella Act because any gap or any environment related issue which was left out can be covered under the Environment Protection Act, and it also ensured provisions for industrial and environment safety, specifically after Bhopal gas tragedy. It was very much pertinent for the implementation agencies and decision makers to enact a law which had provisions for industrial and environment safety and any eventualities of accidents causing a threat to environment, which were not there earlier. Okay, so the bill was passed on 23rd May 1986 and came into effect as a statute book. So it provided provisions for all necessary measures for protecting the quality of environment, lay down standards on discharge of environment. It also established a network of environmental laboratories. So in our country, there is a network of environment laboratory at the NBF, PPCB as well, NABL accredited laboratory, environmental laboratory. So they have specific laboratories for air, water, noise, space, and food laboratories can also be there under environmental laboratories for testing any kind of heavy metals in food metals. And they have to appoint and recognize government analysts, and they have to lay down standards for the quality of environment. Then provisions where under this act, where they can restrict areas in which in any industry operation or processes should not be carried out. Any sensitive location or any protected area, reserve forest area or biosphere reserve or forest area, they can protect. Then they have the provisions to lay down safeguards for prevention of accidents, like remedial measures or for safety audits, for energy audits. All provisions given under EPA. Okay, so under EPA only an environment impact assessment notification came up. Okay, so though the notification is very comprehensive in the clauses and then the kind of conditions it has provided, but it is always considered as a part of Environment Protection Act. So there are rules which have been framed by different agencies and authorities, including EI notification, and they have been notified under specific sections for carrying out specific functions under this act. So the functions included to specify the standards, to rule on an environmental statement. So like financial statement of any industry, all industries are required. Last time also I had discussed that all industries are required to give an environmental statement at the end of the financial year, and where they have to give the details regarding the industry operation processes and its consents under Water Act, Air Act, hazardous waste management rules, and submit that environmental statement in the form of in prescribed format of Form 5 for each financial year to the respective pollution control boards. So under the the hazardous waste management, handling and transboundary movement rules were given, and they provided an effective inventory and controlled handling as well as the final disposal of hazardous waste. So basically earlier what the industries were doing, they were collecting the waste and then disposing it as per their prerogative, as per their fancies or the convenience of availability of any disposal site near their premises. But after these rules, they were governed under the specific of inventory, controlled handling, as well as disposal. So these rules categorized different kind of hazardous waste, and the industry is seeking or industry is generating. Even the hospitals were covered under this rule, and industry is generating all the hazardous waste cannot generate that waste beyond the permitted quantity. So they have to seek authorization from the SPCBs regarding the amount of hazardous waste they can generate, and accordingly their production will be controlled, and accordingly they can generate only that much amount which they have the capacity to dispose of. So they cannot dispose of any kind of hazardous waste haphazardly anywhere without authorization and without declaration to the State Pollution Control Board. So now the possibility of common treatment plant came into picture, because there were many small units which do not have enough funds or infrastructure to ensure disposal of their hazardous waste. So a common treatment facility for all these kind of waste was envisaged, and states started introducing technologies and investors which can install these kind of common treatment effluent treatment plant, common hazardous waste treatment plant were introduced. So the operator of such facility was again required to take environment clearance and authorization from the board, and it will have safe technology as well as specifications for safe handling. So nowadays it is required by all the hazardous waste generating agencies to have a binding agreement with any operator of such facility, and there all the details will be given in a specified format, and challans will be issued for that agency, and the copies of those challans will be given back to the industry so that they can have a record of how much waste they had given to the agency and how much waste they have treated further. So then in municipal waste, against responsibility of municipality was given towards collection, storage, transportation, and segregation of municipal solid waste is again the responsibility of the municipality. But municipality has to encourage citizens to segregate. So part of citizens of citizens of our country comes into picture, that we have to ensure that we segregate segregated materials. So and because of the manpower which is lacking in these municipalities, and the kind of population we have, the high density we have, this cannot be ensured only if municipal level bodies are acting. So there comes the role of each and every individual of our country to ensure that we are segregating, recycle and segregated materials. And also representatives of local resident welfare associations and NGOs were encouraged to be a part of collaboration for municipal solid waste management. Then came. One thing I would like to add to this municipal solid waste. Now, municipal solid waste is again having many categories. Plastic waste management has been added, construction and demolition waste has been added, e-waste has been added. So earlier, waste were part of municipal solid waste only. But now there is separate categorization of municipal solid waste, separate categorization of plastic waste, e-waste, as well as construction and demolition waste. So waste have to be treated independently through their respective disposal agencies. Okay. So then the noise pollution regulation and control rules of 2000 came into picture, where ambient air quality standards with respect to noise levels are, because noise is basically, technically it is a part of air pollution itself. But because air pollution control requires aptitude and different executing agencies, there was separate regulation and rule that was for as noise pollution control regulation and control rules. And the officers again of CPCB and SPCB, the district magistrate, police commissioner, or any officer not below the rank of DSP would be responsible for enforcement of noise quality standards. So they have specified standards as to imposing restrictions on use of loudspeakers, because these are the only mediums of noise pollution at night, or in an organized manner noise pollution is caused due to loudspeakers. So there were restrictions introduced that between 10 p.m. to 6 a.m. And during the festive season, loudspeaker can be used during 10 p.m. to 12 a.m. after obtaining special permissions from the authorities. So if there is any marriage, or if any function on, they are using loud, they're introducing noise levels in your community or the environment, immediate environment, you can always ensure that action is taken against them under these rules and guidelines, and you can have a safe and happy sleep without any noise pollution. So, but you should be aware of what kind of laws and rules are there in the implementation of environment management. That all these rules and applications can be utilized in a proper manner at a proper time and place, and they can be implemented only if the stakeholder is aware about these rules and regulations. And also, as a responsible citizen, if you are taking up any kind of industrial activity, you should be aware that because if you are not aware about you have been asked to pay penalty or you are any action is legal action is taken against your industrial establishment, then the ignorance of the law is no excuse. Okay, so in any case you will be paying penalty if you are not aware about the responsibilities as an industrialist or as a establishment. Okay. So then the ozone depleting substances regulation and control rule 2000 is there, where important aspects of these rules are that no persons shall produce ozone depleting substances. So no ODSs have to be introduced without registration with MOEFCC, and the quantity of production is allowed to be specified. So similar to the Air Act and Water Act, you have to declare this much pollution will be caused, this much wastewater will be this released, this much air pollutant will be released, or I'll be in operations in this much, and I will be taking care of pollution through these air pollution control devices or water treatment plants will be introduced. So under this, every entity that produces, imports, exports, sells, and purchases receives a financial assistance from the international organization to reclaim or destroy ozone depleting substances. So due to these restrictions and prohibitions, again, ozone depleting substances are now their usage is reduced very much, and they have been replaced with better substances that are not ozone or green or not a greenhouse gas. Then the plastic manufacturers usage 2000 it instructed all the manufacturers of plastic with that no person shall manufacture, stock, or distribute carry bags made of virgin or recyclable plastic bags less than 8 into 12 inches. So why this thickness is so important? Because technically, if you higher is the cost involved in collection, segregation, and disposal of those plastic waste. Okay, so that is why thickness is so important in all plastic waste related things, because lower is the size and lower is the thickness in bag or material, it will not be collected, it will not be, there is least chance of getting it segregated and disposed of to the final stage. So that's why it is important that we should not conform to the minimum thickness of 20 microns. And then manufacturer shall print on each packet whether it is recyclable and virgin plastic. That's why if you see any kind of plastic packaging material, you will see there is a triangle. Numeral which is given from 1 to 7 in that triangle, mentioning what kind of plastic it is. Okay, so if it is 5, it is polypropylene. Okay, so if it is 6, it is PS. If it is 2, it is PET bottle. So all these 7 categories of plastic we have different number and different utilization. So even the stakeholder also you should know which kind of plastic is this and how many times I can get, or whether it is of material or whether it is not of food material and I'm not supposed to use it for any food item preservation or collection. So that should be that is your responsibility to make yourself aware. Then carry bags and containers of plastic shall be in natural shade of white, because many times carry bags and containers of virgin plastic were also made of black color. So these are again controlled by BIS standards of IS 9833/1981, and each manufacturing carry bags or recycled product have to again go to PCB, SPCB for renewal of registration, because every time they go for renewal, there is any amendment, they have abide by the amended rules and they have to submit again. For example, EPR report is there, extended producer responsibility report needs to be submitted now as per the amendment. Then is the Public Liability Insurance Act 1991. So it is, the purpose of this act is basically to provide relief to any person who is affected by any accident occurring due to any accidental activities in any industry. Okay, so it environment pollution or leakage of business gases, which has caused any damage to the lives as well as the community or the plants and animals in the vicinity of the industry or the project activity. So it would be the duty of the every owner to take necessary insurance policy to discharge his duties. If any is not taking any insurance under the public liability insurance and this accident happens unfortunately their industrial establishment, then they will not be able to give compensation to the stakeholders if they have not insured themselves. So it is this the duty of every owner which is handling any kind of hazardous substances, because if there is a risk of cause of damage to any community or stakeholder due to the handling of hazardous substances, they will be there can be chances they have to provide compensation to this holders. So the central government then established environment relief fund also in 2008, and this relief fund shall be utilized for provision for with the provisions of this act. Then National Environmental Tribunal Act of 1995 came, where there was an establishment of a National Environment Tribunal, and it was enacted to give relief and compensation for the damages to persons, property, and environment which are victimized due to impact of hazardous substances. So whoever fails to comply with any order made by tribunal, they will be punishable with imprisonment of 3 years or a fine, which may extend to 10 lakh of rupees. Okay, so these penalties and these kind of actions like imprisonment, they are getting stricter and stricter day by day. So again, it is again a kind of economic loss, as well as is very much keen for projecting a good environment of obliging industry. So that image will be hampered if they are not taking care of all these environmental laws and regulations. Again, this act provides for the civil liability for damages, and it has been enacted with a view to give relief and compensation to property in the environment, and the compensation will be given to the victim after receiving a application to the tribunal and the satisfactory inquiry. Again, if somebody fails to comply with the order of the tribunal, they will be given imprisonment to extended to 3 years or and a fine up to 10 lakh of rupees, or both can be given. Then we have the Panchayat Extension to Scheduled Areas Act. People. This is basically for securing property rights under the for the indigenous people movement around the world. And PISA in 1996 was to between the state governments and the tribes. So basically, it gives specific provisions of Part 9 of the Constitution to the panchayats to schedule areas which are so in Punjab, in Delhi, there are no such scheduled areas covered under this act. And there are areas in Rajasthan, in Northeast, and in the states of our country. And the other essential aspects of PISA were the state legislation shall be in consonance with the customary laws and religious practices. Even the Gram Sabhas, they were responsible for safeguarding and preserving traditions and customs of the people. And again, there have been specific powers to the Gram Sabha or the Panchayat for enacting the PIA, for consultation, for organization, for development projects. So under these, any industry acquire any land and establish its development projects without consultation with Gram Sabha or the Panchayat. So it is a responsibility for the industry to consult for land acquisition for such projects with the Gram Sabha. And it also prevents alienation of land in scheduled areas. Okay. Appellate Authority Act. It basically here appeals with respect to the restriction of areas in which any particular class of industry shall not be carried out. So if any industry is causing any kind of pollution and it is under the area of where tribes are located, so PISA will also be implicated. Then Environment Protection Appellate Authority Act will also be implicated. So it is not like in criminal cases or in civil court cases. If there is any offense, it can be covered under different sections and different laws. Similarly, in environment regulations and acts also, if any polluting activity has, you can see what are different acts and policies which are which become active due to that action of pollution. Okay, so there are different clauses which can govern any single pollution activity. Restrict, for example, in this NEA Act, National Environment Appellate Authority Act, it hears an appeal, hears appeals with respect to the restriction of area. So any restricted area or any reserved area, any polluting industry being carried out, it will be covered under this act. So the person aggrieved by any order environment clearance to an industry in a restricted area can apply to the authority of environmental authority. Now, receiving the appeals, this authority can be heard and can pass such order as it sees fit. Okay, so the Protection of Plant Varieties and Farmers' Right Act came up in 2001, and it was passed to provide for the establishment of an effective system for protection of plant varieties. So it also ensured that farmers' rights and plant breeders' rights are protected, and it encourages the development of new varieties of plants under a specific setup of regulations. So the broad objective is to encourage development of any new plant variety and availability of good quality seeds. But it also ensures that the farmers' rights are not hampered, and there is mandatory for every breeder to notify the expected performance. Okay, any kind of new variety cannot be induced in the system to cause any gene variation or any kind of you can say exotic species cannot be introduced. So they have to ensure that what kind of performance genetic product they genetic variety and how conditions it will be working in, and what are the researchers who are allowed to use any of the registered varieties. So it is basically to ensure that there is no any species which can cause can erase all indigenous species of the same plant or product. Okay. Then Biological Diversity Act came into picture in 2002 because with land area we recorded in India, which accounts for 8% of the recorded species of the world. So it is very pertinent for our country to ensure that whatever biological diversity is left in this 2.5% of the total land area, it is preserved in its best of the spirit. So the India is also again a party of biological diversity in 1992. So and as a party to that convention, it has certain responsibility and certain submissions to fulfill for any period of and this convention is again held up. So during that international or national. So the act primarily addresses the issue concerning access to genetic resources and associated knowledge by foreign individuals. So any kind of foreign individual or foreign researcher cannot come to our country and use our resources or use our indigenous knowledge of medicinal plants or biological diversity for their scientific purposes. Before any kind of study is implemented, they have to missions, they have to register themselves. And again, it has provisions of creation of National Biodiversity Authority. So this authority, similar to Central Pollution Control Board, it is having a chairperson, one person representing the ministry dealing with tribal affairs, and two persons representing the ministry. There are 5 non-official members to be appointed from a specialist and scientist. Okay, so this National Biodiversity Authority was not in picture until 2002. It came into picture in 2002, and that's why the person and the committee, which is the authority, the members which are there, they have the benefit of sharing the rich knowledge and experience in matters related with conservation of biological diversity and ensuring country ensure area which have been high in biological diversity. And the functions and power NBA ensures to advise the central government on matters relating to conservation of biodiversity. For example, if tiger population reduces from certain level from and reaches a critical level, have to suggest central government to plan and provide funds and investment for introducing conservation plan for tigers or for any other species. I'm just giving you an example. So if you go to the Ministry of Environment Forest site, there are annual reports given for the actions taken up and the projects taken up for the protection of biological diversity in that financial year. And then it also advises the state governments for selection of areas of biological importance and to notify the heritage sites in its area. For example, international Ramsar wetland sites have been identified in our country location. So those kind of recommendations come through the Biological Diversity Act and comes to the National Biodiversity Authority. Okay, so authority may, on the behalf of central government, take measures necessary to oppose the grant of intellectual property rights, because even the Biological Diversity Act has researchers and scientists who have identified certain rich biological resource areas in our country. Okay. So that IPR, the grant of IPR is also governed by NBA under this act. So now coming to significant case studies of landmark cases or classical cases of environment pollution and mitigation. There is a Taj Mahal case where now also that Taj Mahal is one of the wonders of the world. It is pride of our country, and all tourists throughout the world, they are keen on visiting our country and viewing Taj Mahal as one of the wonders of the world. And because it was faced with the threat from pollution caused by Mathura refinery in 1984. There was high level of pollution caused by Mathura refinery. So iron foundry as well as glass and other chemical industries. So there was many registered and unregistered industries and segregated industries operating within the vicinity of Taj Mahal. So as a result of very high toxic emissions from these industries, and there were many other 255 other historic monuments within the Taj trapezium zone. So in the vicinity of the Taj Mahal itself, ranging from 4 to 10 kilometers. There was a trapezium area was there, and there were around 255 historic monuments in that area. There were many small, some of them were identified under Heritage Act and some were not identified, but still they were historic monuments. So they were facing threat due to high level of acids in when it used to rain in those areas. So that any kind and when your rainwater is having acidity less than 4, so it is called acid rain. The petition was filed in the year 1984, and the Supreme Court of India delivered a historic judgment in December 1996. He is the basic pioneer of environmental cases and landmark cases in those years. In 1984, he made many such landmark cases. So MC Mehta is basically the main advocate behind all the landmark cases relating with the environment management. So the Supreme Court of India delivered a historical judgment in December 1996, and the apex court gave various directions, including banning the use of coal and coke. And till now, if any new industry has to establish itself within the trapezium zone of Taj Mahal, or it has to expand itself in the trapezium zone, there is no provision under environment clearance regulation. It has go to Ministry of Environment and Forest. And so I did one case in trapezium zone also for environment clearance of a hospital. I'll not name that hospital the obvious reason, but the case was prepared, and it was given that this hospital utilize this much number of DGsets, and only air pollution causing devices DGset. So if there is continuous power supply from the state, that will also not. So for the benefit of the population, for providing better health facilities, the expansion of that hospital should be allowed. That was our to so that hospital can get expanded, and it can provide beds for larger number of patients. Not given information till now, what I am aware of, in spite of preparing a full-fledged report. So that was the impact created by the Taj Mahal case, and it is lasting. That impact is still lasting as per the regulations and rules that were drafted after this landmark case. Okay, then there was a significant case study of Ganga pollution. So 3 landmark judgments and number of orders under the many industries. There were more than 100 industries which were still there. Many industries issued show cause notice. So more than 50,000 in the Ganga basin were given, and from time to time still there industry which is there in the Ganga basin, and substantial success has been achieved by way of creating awareness and controlling pollution. And apart from this, in these industries, more than 250 towns and cities have been ordered to put sewage treatment plants to ensure that they do not release polluting effluents to the Ganga stream. And 600 tanneries operating in the congested residential area of Kolkata, they have been relocated in a planned leather complex. Okay, so special economic zones and special industrial complexes were defined after these landmark cases. So in those areas or special economic zones or special industrial zones, all the effluent treatment plants or common effluent treatment provided within that. For example, 50 leather units, all the leather units will be having similar kind of effluents and similar kind of polluting activities. So it's better to employ a technology in those special areas by the central government or subsidized by the state government, and that will ensure that these leather complexes, they have best of the best to